My name is Mr. Corey Schweitzer. Today's date is January 16th, 2026. Yesterday, during the bar hearing for the Idaho State Bar against April Smith, Deputy Prosecutor of Nez Perce County, we had an interaction. When I joined the Zoom chat, the bar hearing administrator was instructing the community member that they were going to have a nice quick hearing. Actually, I think the correct verbiage was, yeah, we're gonna rush through this. At which time then Carole I announced, Mr. Schweitzer, would you verify that your audio is working? Immediately I went to my computer and typed this up into the document hearing that I had prepared. Here's that audio transcript of how it went.
Good afternoon, Ms. Murphy. Can we verify your audio is working?
It's working.
Great. All right. We are all here. I'm going to start the recording and then you may begin, Ms. Chairperson.
Recording in progress.
Thank you. This is the time and place for review hearing in the matter of Smith, Idaho State Bar Complaint Number 25-168A. This hearing is being conducted pursuant to Idaho State Bar Commission Rule 509D. This proceeding is being recorded by Madam Clerk. First, I'd like all the parties to identify themselves. I'll start with committee members and then the parties. My name is Carole Wesenberg and I'm the chair of the hearing committee.
I'm Mia Murphy, member of the committee.
Sherry Montoza, committee member.
My name is Mr. Corey Schweitzer. I am the grievant.
And I'm April Smith.
Thank you.
May I make a recommendation that Mr. Schweitzer please turn on his camera so that we can see him?
I'm very sorry.
Thank you.
Yep, no problem. I have sight issues.
Will there be any other witnesses or parties appearing today?
No, ma'am. I'm just letting you know I have sight issues and my camera is shaky because it's on a card table.
Okay.
I have obviously sight-related issues and I have some audio processing issues. So if I ask you to repeat questions, please be patient with me.
Okay, no problem. So there's no other witnesses or parties?
Not at this time.
Okay. So the claimant, Corey Schweitzer, has requested this hearing for purposes of reviewing the Bar Council's May 29, 2025 decision, finding that claimant has not met his clear and convincing proof that Attorney Smith violated any rules of professional conduct. The committee has been provided with a written record of this matter, specifically been provided with the record base stamped 1 through 300, the supplemental record base stamped 1 through 1,551, the grievance references for all hearings, the grievance supplemental filings, The audio recordings from both Mr. Schweitzer and Ms. Smith's recording of the June 21st conversation. And the record generally consists of the initial complaint, record correspondence to and from Bar Council and the clerk with the parties, and the Bar Council's decision. And yes, sir?
I'm sorry, but one important thing has not been included into that record, and that is the email generated just about 2 hours ago detailing April Smith's romantic relationship with Rick Fuentes. I would like to ask, have you received that email, and is that included in this record?
We did receive that email. I don't understand the relevance of that with regard to this hearing.
I will certainly be able to elaborate on that during this hearing. Please include that in the record as requested. Thank you.
All right, so we'll include that in the record, and then it will include everything that has been filed or circulated as of today. So are there any additional documents or written materials that either party wants to submit that's not been made a part of this record yet?
Not at this time. Thank you.
All right. So based upon that representation, I'm going to close the written record that the committee will review for rendering its final decision. So our procedure today is that Mr. Schweitzer will go first and present his argument and testimony and any evidence that he wants us to consider. We'll then give Ms. Smith a chance to respond and present any argument testimony that she wants the committee to consider. We'll then give Mr. Schweitzer the final say, given that you're the party that requested this review hearing. So before we get started, I just want to clarify a few things for the record. So Mr. Schweitzer, you requested that your cases be consolidated. The Supreme Court has decided that issue, so we're bound, the hearing committee is bound by that decision, and therefore I request that you keep your comments and allegations to those against Ms. Smith. You also requested for a special prosecutor to be appointed. That request is beyond the jurisdiction of this hearing committee. And finally, I just want to make sure that we all understand what the standard of proof is for attorney discipline matters. So pursuant to the Idaho Bar Commission Rules 525E, the standard is clear and convincing evidence. This is a standard of proof requiring substantial corroboration to establish disputed facts. Clear and convincing means that the evidence is highly substantial and more likely to be true than untrue. So in other words, it's typically higher than a standard of the civil procedures, which is preponderance of the evidence, which is more likely than not, and a lesser standard than beyond a reasonable doubt in criminal procedures. So is there any questions with regard to our procedures today?
No, ma'am. However, I will be renewing my objections.
Okay. All right, so Mr. Schweitzer, you may proceed.
Thank you. To the hearing committee, I appear before you today under a formal protest. This proceeding, like the fractured reviews of Justin Coleman and Trey Turner, is a product of a disciplinary process that is structurally incapable of fairly adjudicating the interconnected, systemic misconduct at the heart of these grievances. Therefore, before addressing any of these merits, I formally renew my objection and demand immediate appointment of a special prosecutor from outside the Idaho State Bar's hierarchy. This demand is necessary because, first, the bar process has repeatedly demonstrated bad faith. From the outset, the bar has engaged in the same compartmentalization and dismissiveness it is supposed to investigate. My grievances document a single collaborative enterprise involving Smith, Coleman, and Turner. By fracturing this into 3 isolated hearings, the bar guarantees that no committee will be ever compelled to confront the scope of this corruption. This is exemplified by the statement made by you, Carole Wesenberg, to Sherry Montoza before this hearing today when I joined this Zoom chat, to rush through this hearing as quickly as possible, ensuring the boilerplate denials an inherent bias towards colleagues and grievance.
Mr. Schweitzer.
Please, I am not finished.
I can ask questions.
Sure.
So I'm just going to make a comment with regard to that. My comment to Ms. Montoza was that we were going to close the hearing today and not allow for additional evidence to be submitted because we have plenty of evidence. Most of it has been duplicative, and so I don't see that there's any new evidence that's coming in. So that was the idea, is to close the hearing today so that we can issue a decision rather than extending it for you to submit additional information.
It ends up being the same. Your explanation is meaningless when the framework of boilerplate denials continues. May I please continue?
Yes, you may.
Second, the resistance is a complete evidentiary record that proves this point. All three hearing committees initially issued boilerplate denials labeling an integrated bait stamp evidentiary record as a data dump, only after a sustained objection and the forced admission of the Coleman study guide in one hearing has the supplemental information been begrudgingly accepted. This pattern of resisting the facts mirrors the very obstruction being alleged, as well as your personal statement to them to rush through this hearing, ensuring that this hearing will not be fair. Third, the web of conflicts is now a tangled knot of corruption. It is a matter of record that Trey Turner's wife is an employee of the same Nez Perce County Prosecutor's Office, the same as April Smith, the office that run by Justin Coleman and staffed by April Smith. When the attorney of the accused company is married to the prosecutor in the same office, accused of obstruction, and donates to their elected chief, impartiality is impossible. Further, evidence submitted this morning, a YouTube video published of David Walk from Walk This Way Media, contains testimony from a former Lewiston police officer alleging that April Smith had an affair with Commander Rick Fuentes during the Joe Thomas murder trial. Rick Fuentes is one of the three officers eyewitness accepting cash bribes from Tim Kruger and has been reported to April Smith. This committee is now being asked to impartiality judge a prosecutor whose alleged personal entanglement is a key figure in the very bribery scandal she suppressed. This is not a hearing. This is a charade. Only an independent special prosecutor, free from these personal, financial, and professional entanglements, can conduct a unified investigation that justice demands. And when I receive the boilerplate denial from this bar that I expect, I am taking this to the federal level. Thank you.
So, any of the committee members have any questions for the claimant?
Those are just my opening issues, ma'am. I am willing to also give the substantive violations, the suppression of felonies and personal conduct in my opening statements. This is just regarding the personal issues I have with the procedure. We can continue on.
Okay, so if you have more to say, you can continue
I
on.
do. To the members of the committee, setting aside the procedural corruption, the substantive violation by April Smith is clear, documented and compounded by a devastating personal conflict. On June 2nd, 2021, April Smith committed an act of obstruction. Her email to Officer Lines, "You do not need to do any additional investigation in this case," was a direct violation of IRPC 3.8D, her sacred duty as a prosecutor. By ordering the investigation to stop, she prevented any evidence from being collected, the ultimate form of suppression. Why did she sue?
Mr. Schweitzer, was that with regard to the assault
Yes.
case? And so do you disagree that you had agreed civilly to not pursue criminal charges against that person?
No. In fact, the evidence that I submitted today, emails shortly before this hearing, demonstrated that I wish to press charges against Troy Munsterman. I said this directly to April Smith. So can you please rephrase your question?
So did you, during the phone conversation, did you admit to having reached an agreement with his brother about not pressing charges?
No. That agreement was on the contention that they would pay for the dentures that I currently have to wear. They didn't pay for those. They didn't do anything. Instead, after I uncovered evidence of police department, or evidence of the tax evasion being committed by Traveland RV, they decided that they didn't have to pay for it anymore.
So would Miss Smith know any of this information at the time you talked to her?
Yes.
Okay.
May I continue? Why did she choose to suppress it?
It's the violent felony assault, first of all, the nexus of interconnected felonies. During that same phone call, I presented Smith with the credible evidence of other felonies stemming from the same location actors, including the felony forgery and fraud. That's 22L 537, the forgery of a Washington state title document by Megan McCreary. Also, the tax evasion, evidence of substantial tax fraud by Travelland RV, later confirmed by Idaho State Tax Commission liens. In addition to the withheld title, that the title was also forged, sent to investigator Monty Schmidt of the Idaho Department of Transportation, and the attempted extortion by sales manager Sean Whitmore. All of these have been sent to April Smith's office. None of those have been investigated, prosecuted, nothing. It's been completely ignored. Most critically, her order suppressed the pathway to investigating the police department bribery that I've witnessed. The officers involved, Rick Fuentes, Andrew Fox, that's the officer in 22L 5337, and Nick Woods, a prosecutor within her own, detective within her own prosecutor's office. These were all the subjects of these allegations. Now we must confront the revelation of Smith's alleged personal conflict having a romantic relationship with Rick Fuentes. This isn't just willful blindness. It's a profound personal conflict of interest that directly explains her motive to obstruct. Smith's directive was a strategic decision to bind her office and blind it to an entire pattern of criminal activity to protect her professional colleagues and, allegedly, a personal intimate. This conduct is prejudicial to the administration of justice. This act was a keystone and an arch of protection. It protected her boss, Justin Coleman, from scrutiny. It protected Travelland RV, the client of attorney Trey Turner, and who, by the way, still has a wife in that same prosecutor's office. It protected Commander Rick Fuentes, whom Smith had allegedly a personal relationship. This activated a circular system of dismissal to bury the truth. The evidence is all before you, at least it should be. The stop investigation order, the felony assault report, the forgery and extortion cases, the tax liens, Turner's campaign donations to Coleman, his wife's employment in the prosecutor's office, and now testimony of Smith alleged after the bribe police commander. You are being asked to judge a single unethical act, but it cannot judge it in a vacuum. You must see it as it was, a deliberate, personally conflicted act that ignited a coordinated scheme to use a public office to protect the private power, to shield corrupted officers, and punish the whistleblower. In the absence of a special prosecutor, this committee has a duty to confront this pattern. Find that April Smith violated IRPC 3-8D and 8.4D. You need to sanction her meaningfully, and you need to break this cycle. The integrity of the profession and the public's trust demands nothing less than a full investigation and not a rushed hearing. Thank you. Do you have any questions?
Do the committee members have any more questions or any questions?
I may after I hear Ms. Smith's testimony.
I don't at this time, thank you.
All right. Do you have anything else, Mr. Schweitzer?
No, ma'am.
Okay. Ms. Smith, you now can respond.
Thank you. I would just ask the committee to uphold the finding of the bar that the complainant has failed to establish clear and convincing evidence of a violation of the rules of professional conduct. I exercise my discretion as a prosecutor, and as the bar previously outlined, I do have wide discretion as a prosecutor on whether to prosecute or file a case. This is specific to the battery complaint that Mr. Schweitzer made to the Lewiston Police Department. After review of the evidence in that case and speaking with Mr. Schweitzer, I determined that I was going to decline prosecution in that case. And the rules of professional conduct related to prosecutorial discretion are wide and allow for me to make that decision. Mr. Schweitzer brings up multiple other instances, but the prosecutor's office does not investigate cases. We just review investigations conducted by law enforcement agencies and determine whether to prosecute those cases or not. And so the only investigation I have ever reviewed related to Mr. Schweitzer is the battery investigation that he has spoke of. And so based upon all of that, I would just ask the committee to dismiss the complaint. Thank you.
Ms. Smith, so was the purpose of your dismissal or failure or your determination not to pursue it based upon the agreement that he entered into?
Yes, the information that I had is that he did enter into a civil agreement. It took him multiple months, and after a further disagreement with Travel and RV, Mr. Schweitzer, reported it to police. I also believed that Mr. Schweitzer is not credible, and credibility is a decision that I have to make when I decide whether or not a jury is going to believe the evidence that I have in front of it. And I determined after reviewing everything that he would not be credible to anybody who listened to him. And so it's based upon the civil agreement and my conversations with him about that decision.
And does that go then to the allegations of fraud and tax evasion, bribery that he also raised?
I have never been presented with any investigation related to tax evasion or bribery to review to make a determination. I don't believe that has ever been investigated by any law enforcement agency. And Mr. Schweitzer did say the word Washington a lot when he was speaking, and I don't have any jurisdiction for things that happened in Washington.
So he raised that issue on the phone conversation, but you didn't have anything before you to investigate anything before that?
Correct.
Okay, thank you. Anything else, Ms. Smith?
No, thank you.
Do either of you have any questions for Ms. Smith?
So just to be clear, the alleged battery occurred in Idaho?
Yes, it did. It occurred in Nez Perce County, Idaho.
Where is the travel land location?
It's within the city limits of Lewiston.
Okay. Thank you.
I have no questions, thank you.
Okay, thank you.
Thank you. Okay, Mr. Schweitzer, you have the final say, so you can respond to Ms. Smith.
Absolutely. And Ms. Smith, thank you for your admission that none of those things have came in front of you, because as the documented in the emails that I've sent today, it said that the prosecutor's office had been contacted. You would be that primary contact within that prosecutor's office for filing criminal charges. These were all laid out in front of by Andrew Fox, one of the 3 people that I watched taking cash bribes. This was also said by Jason Marchetti. I apologize, I've got the sniffles. Jason Marchetti of the City of Lewiston Police Department, also represented by Trey Turner, that he forwarded it to the prosecutor's office and that they declined prosecution. So there is 2 stories that are going on here, where the LPD says that they contact the prosecutor's office then allegedly contacts the LPD and says that they declined to prosecute. That's not the case, since Ms. Smith said that she's never received any evidence from the LPD. Therefore, she is affirming what I am saying, that there is a circular logic of protection that is going on here. Whether or not Ms. Smith thinks my statements are credible or not seems to be irrelevant, because I have clearly presented this evidence to the Idaho State tax investigators, and they found that to be credible, and they assigned 32 different tax liens to Travel Land RV, including a judgment with Libertas Funding. In the end of 2023, when Travel Land RV had a slew, probably about more than a dozen, 18 different counts of tax evasion, they got a receipt loan from Libertas Funding in a receipt lending provider. And in doing so, that lending provider then said that once you pay the receipts, we'll take that back. Instead, Travel Land RV drained their bank accounts and paid off all of their tax liens. That didn't solve their money issues, though, as it continued to collect liens. And through that evidence that I presented to both April Smith, the City of Lewiston Police Department, notably one of the officers I watched taking bribes. This whole thing is just one circular logic of we're not going to do anything and punish whistleblowers and call them not credible. There is nothing to suggest that I'm not credible. I presented this evidence to you. I presented this evidence to April Smith. Her primary duty is not to halt investigations, but to look at the evidence in front of them. And by April Smith's comment to the City of Lewiston Police Department from then forward, justified no more investigations needed to be done. Of course, April Smith is completely allowed to attack my credibility. There is nothing to suggest that my credibility is at stake here. I am not the one on trial. Thank you very much for this exercise here today in the legal process, and I fully expect a full boilerplate denial rather than the Idaho State Bar attempting to adjudicate one small part of a much larger criminal picture. Thank you.
Does anyone have any additional questions for Mr. Schweitzer?
I just have one. Mr. Schweitzer,
Yes, ma'am. Yes, ma'am.
what relief do you want?
I would like to see April Smith, Justin Coleman, and Trey Turner at very least suspended from their ability to practice law for the minimum of 2 years and a re-education program. This is unacceptable to have a prosecutor receiving campaign donations from the same conflicted counsel that April Smith works under. I would like to
So
see
just to be clear, you
Yes.
would like them to be suspended from...
a minimum of 2 years.
All right, thank you.
Thank you.
Any other questions?
No.
All right, under our rules, the committee has 21 days to get out its written decision. I fully expect a decision from the committee within that time frame. Once we issue our decision, it'll be provided to Madam Clerk, and she will serve it upon the parties. So I appreciate everyone's participation today in the hearing, and that concludes our hearing for today. Thank you.
Thank you.
Recording stopped.